Hi, everybody, and welcome to our webinar on SCOTUS nomination and confirmation process. I'm Kathy Ruffing. I am the Senior Director for Teacher Professional Development Programs and Curriculum at Street Law. And today we'll have Gregg Nunziata and Jack Quinn with us to help give us a lot of background on this process. So I'll start out by introducing Gregg. Gregg is a partner at Manatt and in the government and regulatory section. He was general counsel to Senator Marco Rubio. He was chief nominations counsel to the U.S. Senate Committee on Judiciary, and he played a vital role in the confirmation procedures for Chief Justice John Roberts Jr. and Associate Justice Samuel Alito. And what it doesn't say on that is that Gregg is also a great friend to Street Law. He has volunteered on many occasions to talk to our teachers in the Supreme Court Summer Institute and has helped with materials review, including one of the things I'm going to talk about today, which is a short explainer on the nomination and confirmation process. So I'll turn it over to Gregg to say a few words.
Yeah, no, just happy to be here. I've always enjoyed working with Street Law, and I was disappointed that COVID meant we couldn't do this in person over the summer. So I'm glad to be able to talk to some teachers now. And if you have questions after this, hopefully we can cover them. If we don't get to it, please kind of make a note of my name and feel free to shoot me an email later or over the course of the year as you're teaching these things to your students. I'm really happy to help.
Thanks, Gregg.
Thank you.
I'm going to introduce Jack Quinn. We're having a little conductivity problems right now, but hopefully he will be joining us very shortly. So Jack is Gregg's partner at Manatt and also in the government and regulatory area. And he was counsel to President Bill Clinton and especially worked with him on judicial nominations. And he was chief of staff to Vice President Al Gore. So you can see that we have experts today, both who lean conservative and who lean liberal, and also representing the Senate part of the process and the president's part of the process. So we have all of our bases covered. So we'd like to see who is here today. And if you would give us a little introduction in the chat, tell us who you are, what school you teach at, what state you're from. We'd love to see who's here. A lot of times people who have been to our institutes are able to see their friends in the audience, and we're able to see people who we have some names that we know and meet some people we don't know. So please feel free to use the chat function. Please make sure you message all panelists and attendees if you would like everyone to see. And while you're doing that, I'll do some more logistics. So we have some materials with this webinar, including the PowerPoint we're going to use if you'd want to repurpose it and use it with your students. So that QR code, if you just pick up your phone and hold it at the QR code, you don't even need a QR code reader, just turn your camera on. It will take you to a file folder that has links to these materials. You can also use that little bit.ly right there that Ben Marks will drop in the chat box when he has a moment, and that will take you to all the materials you might need. Seems like we're all very comfortable with Zoom these days. So I probably don't really need to say this, but just in case anyone's new to this platform, we're going to use two ways for teachers to participate today. The Q&A function, where you can leave questions throughout the webinar that we may sort of incorporate as we go, or we might hold to the Q&A section at the end. One of the great functions on this Q&A feature is that you can upvote questions. So when you go to write a question, before you put your question in, glance at the questions that have already been submitted. And if you see one that's very similar, you can upvote it. And we may not take them exactly in the order that they're upvoted, but we'll definitely look at the ones that have been upvoted the most first, and so they're more likely to get answered. You can also put questions in chat, but that's probably best reserved for questions about technical assistance. So we have with us today Ben Marks. He is our communications coordinator at Street Law, and he can help you if you're having issues being able to use any of these functions. I also wanted to mention at this point that there was an option when you registered to submit questions. We have over 35 questions submitted at this point. So I've shared those questions with Jack and Greg, and what I've asked them to do is sort of to incorporate that in their presentation and the things that they talk about. So while you might not hear your question actually read in the words that you sent in and in a Q&A fashion, you might hear them incorporated into their presentations. So that's the hope. And then we will have a Q&A section at the end where we'll bring up some of the questions that were submitted, and we'll take some questions out of the Q&A queue at that point. Okay, I'm just going to do a brief introduction before I turn it over to the experts. And this is sort of the government teacher thing. So some of you know that I taught AP government for 27 years. So there's all that government teacher still in me. So, you know, be remiss if we didn't point out that really the only words in the Constitution about this process that we're going to spend an hour talking about, and you could probably spend a whole semester talking about, are the words in Article 2, Section 2, where it says that he shall have the power by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. So lots of question about what exactly the advice and consent of the Senate is, and that's all we have to go on. So most of us have in our textbooks a flow chart that looks something like this in some way, shape, or form. And we all teach our students that the process starts with the president and nomination, and then moves over to the Senate Judiciary Committee, and finally to the full Senate. And again, this looks pretty short and sweet, but we know that the process in real life is much more complicated, and that's what our webinar is going to focus on today. It's going to focus on what really happens, and we're going to get to hear the insights of people who have had a front row seat to some pretty historic nominations and confirmations. And of course, we're helping our students navigate through the current nomination and confirmation, and things are unfolding. Just today, there were some fireworks and some procedural chess playing today that we can talk about. So we're going to move on to the nomination process. Before we do that, I'm going to tell you how this is going to work. So Jack has, as our representative of the executive branch, has a lot of experience in the nomination process. So he's going to talk through the nomination process in a sort of frequently asked questions sort of way for about 10 minutes. And then at that point, we're going to give Greg about 5 minutes to give his perspective on it, his perspective as maybe someone who represents a more conservative viewpoint, and also as someone who saw this from the Senate side. And then Greg is going to take the lead talking about the confirmation process. And at the end of that time, we're going to give Jack about 5 minutes to talk about his insights into the confirmation process. So they're friends, they're partners at their law firms. They might sort of interject with each other every once in a while, and I think that's an okay thing. And I might interject as well with some questions that we received before this started. So we'll start with the nomination process, and we'll welcome Jack. Jack, I introduced you when you were not on the line. So if you want to start off also by saying some words, that's great.
Oh, go ahead. Sorry.
No, please do.
Do you want to start with what does a president consider?
Sure, yeah.
So, first of all, let me say that Greg and his friends have had a lot more opportunities to work on these Supreme Court nominations than we Democrats have.
But we choose poorly more often.
I don't know about that. You know, the process is an extraordinarily serious one and an intense one, as you've probably gleaned from just looking at some of these materials, particularly in the case of a Supreme Court nominee. The public part of that process happens. You know, people who are nominated for the district court and for the courts of appeals tend to be in a process that moves at a slower pace, but and importantly, not nearly as much in the public eye. You know, that's the case only if a court of appeals nominee was, for one reason or another, unusually controversial, or if something quite surprising came up during the public part of the process. You know, but essentially, the White House counsel, working very closely with and supported wonderfully by the Office of Legal Counsel, will be maintaining vetting files of people who might be nominated for these incredibly important positions. And so there's an awful lot of stuff that leads up to a public nomination by the president. But you know, the process is essentially the president working with the counsel, his counsel, White House counsel, and the Office of Legal Counsel, having a list and then a short list and then a nominee, and then essentially putting that person into the process, which means going before the Senate Judiciary Committee, which would vote whether or not to bring the nomination to the floor. And then when that does occur, then the full United States gets to vote by majority vote. We can go into the nuclear option, all that stuff later, but it's really not terribly relevant these days. And then, you know, the question is, how does a person get on the list? What are the qualifications? What law school do you have to have gone to? What church do you have to have gone to? The answer to that is there's no requirement of any kind along those lines. There are no specifics set forth in the Constitution as to the age of the person nominating, the religion of the person nominated, the sort of political orientation or ideology. There's no reference to people who've been nominated before and in search of finding some kind of balance on, or not exist. Indeed, some people are surprised to hear that you don't have to be a lawyer to be on the Supreme Court. And there have been members of the Supreme Court who, in fact, you know, were not lawyers, or at least did not go to law school. It's really a question of just getting enough votes, getting the support of a president, and getting enough. There's no gender test. There's no religion test. We, on the religious side, you know, I think the remarkable number of Catholics on the Supreme Court, I think that there's only one person who's Protestant.
That's right.
Justice Gorsuch.
Yeah.
That's really pretty surprising. But it's an accident, by the way. It's not the result of any plan on the part of multiple presidents.
So Jack, would you say that, because I just flipped to the balancing the court side, would you say that religion is not something a president considers nowadays when he thinks about balancing the court?
In my judgment and my experience, is not. I really do think that each president, generally speaking, chooses somebody who will be the kind of justice that would reflect the president's ideology, if you will, and views on the law. That doesn't always work out, by the way.
Right.
President Eisenhower, a pretty mainstream nominated Earl Warren. He turned out to be one of the most liberal justices in modern times. Ditto for FDR's nomination of Hugo Black from Alabama. Hugo Black from Alabama was about as far left as we've seen on the Supreme Court. So you can't, there's no redo. You can't. The president can't call them back. Once they're there, they're there.
There's a story about Eisenhower, I don't know if it's apocryphal or not, but that he was once asked what his biggest mistakes as president were, and he said, they're both sitting on the Supreme Court.
That sort of thing happens. I mean, that's the, it's a lifetime appointment, and you have to live with that. I mean, I'm looking at the page called, what is the and there are, the first reference I heard to litmus test really, I think, involved abortion. It's been applied in other contexts as well. But there have from time to time been issues in American public life that of course have been reflected deep divisions in the electorate and intense passions. And when that happens, it's not surprising that the political players who attach themselves to those issues want to apply a rigorous test of adherence to the views of a particular interest group in determining whether to support a nominee for certainly the Supreme Court, but oftentimes the courts of appeals as well. And to be willing to make the whole nomination stand or fall depending entirely on that one issue. In modern times, since Roe v. Wade, that has typically been the case in the instance of a nominee's views on abortion. I'm going to digress a little bit here. One category of people who have sort of fallen out of favor in terms of nominations to the Supreme Court, and we talked about two of them here, Earl Warren and Hugo Black. We don't put politicians on the court anymore. And I have long objected to that. and I think the reason is there's a whole swath of jurisprudence that would really benefit from people understanding a little bit about how politics works, whether it's campaign finance, or other issues that really grow out of that area. So for example, the conviction of Governor, oh my gosh, the Virginia governor, I was on his amicus brief too.
I forgot his name already too.
McDonald.
Yes.
It has always struck me that whether you're talking about whether, soft money or hard money or, all of these things should pass constitutional muster, it would be helpful if the judges and justices making decisions on those issues had some experience in the field. And these days they tend not to have. Anyway, that's just an observation.
Speaking of politics, so the next slide is about the role of interest groups. So today, if people watched the hearings, they heard the very first outside witness to testify was two representatives of the ABA who were there to present their findings about about the rating of Judge Amy Barrett. And certainly we've heard a lot about the Federalist Society in this nomination and all of Trump's nomination. I mean, he ran on a short list that was basically provided from the Federalist Society. And I know that I noticed from the names, a lot of AP government teachers out there who often ask their students, or the College Board asks their students, what is the role of interest groups in this process? So maybe you could speak a little bit to that question.
Yeah, sure. And so do ABA ratings still matter? Yeah, I think they do still matter. I think it would be hard to advance somebody to the Supreme Court who was deemed by the ABA to be unqualified. Having said that, I don't think it has the juice it once did. You mentioned Federalist Society. I think of all the interest groups in the legal sector, the Federalist Society at this time and recently is the by far most effective and influential in the process. There's just no doubt about it. It matters, but it's not dispositive. They don't have a veto. And, you know, as you note here, there are other groups, the American Constitutional Society and so on, the Federal Society, the ABA, they all have a role to play. But none of them sort of, you know, dictates calls the tune here. I did want to tell you that one anecdote that I mentioned to you, Kathy, about how Senator Hatch, at one point when I was President Clinton's counsel, they really slow rolled us in the Senate in terms of getting hearings, votes on our nominees, and so on. And I had developed a really, truly fabulous relationship with Senator Hatch. I mean, we got along really, really well. And I was constantly going up to see him. I need more hearings. I need more votes. I need more opportunities to get our people exposed to the committee and so on. And he said to me one time, Jack, you know, did you ever think about giving me somebody I could kill? And I said, what do you mean? He said, you know, somebody we could just really take to the woodshed and vote down. He said, you know, that might help sort of unclog the process. And I said to him, Mr. Chairman, exactly which one of President Clinton's roommates from college or from law school do you want to kill? Because President Clinton had a remarkable number of close friends from Yale Law School who you may know now sit on the bench in different places in the country. So let me talk quickly about what vetting takes place before and during the nomination. Again, as I alluded to it a little bit earlier, this doesn't start on the day when a Court of Appeals judge or a Supreme Court justice passes away or retires. That's not the beginning of the process. The White House counsel, the Office of Legal Counsel, they're maintaining vendors of materials on people who might potentially be nominees constantly. I mean, these things are kept up to date. And so when that process kicks off with the opening of a vacancy, there's a body of material that's pretty much ready to go. And it's pretty easy to develop at least an initial short list of potential nominees. And, you know, that's when the one or more of the people on that short list, usually 3 or 5, will be vetted with some intensity leading up to a decision by the president, which of them he or she would like to formally nominate.
That's a good segue into our last question before we give Greg a moment to add his insights. And that is, is there any significance to the official nomination announcement? Is it just a pep rally? Is there, what do you think is the importance?
I mean, you're leading with your chin here. I can't help but say it's a super spreader event. It's an opportunity for the president to put on a pedestal in front of the country. That tends to be a helpful part of putting some wheels under the nominee and some momentum toward confirmation. I think that's about all it amounts to.
Okay, Greg, we'll give you a few minutes to add anything that you'd like to, from your perspective, to the nomination process before you jump into the confirmation process, and we let Jack do the same at the end.
Sure. Jack is normally quite sound, so I don't have anything to really disagree with or amplify or shade. But I'll just say on the pre-nomination process, sometimes people ask me about the Senate's involvement. They read the Constitution, advice and consent. Does that mean that senators are advising the president on who to nominate? Kind of as an originalist matter, I think it's pretty clear that the founders didn't expect the Senate to have that role. If you read the Federalist Papers, they're pretty clear that the Senate's entire role is just saying yay or nay on who the president chooses, not telling him who to choose. In reality, senators are powerful. And particularly within their home states, there's a thing called senatorial courtesy, where the Senate will defer to home state senators on, say, district court judges in their state. That has given senators leverage. And in the case of trial court judges, senators often really do the selecting with the White House's blessing. With appellate court judges, the balance is quite different. The White House is in the driver's seat, but they consult with the Senate a lot. Supreme Court justices, the White House, it holds strong to its prerogatives. They may make a show of having a few phone calls with important senators. Senators might send up lists, but the White House is deciding, and it's not a consultation. So I think that's all I'll add to the pre-nomination process.
Okay, great. Okay, on to confirmation.
So, the Senate's role is simply to say yes or no, and that's how it began. And in the earliest confirmation processes were pretty quick. Sometimes Supreme Court justices were confirmed the same day they were nominated, or within a matter of days. In fact, I think the last person to be confirmed the same day he was nominated was in something like the 40s or 50s, really recently, surprisingly. But Senate involvement has ramped up over time. The Judiciary Committee first got involved in the 1890s. Before that, nominations to the Supreme Court just went to the full Senate. Hearings started in the interwar period, and there's a little bit of an ugly origin story to Judiciary Committee hearings and Supreme Court nominees, because the first couple were really, or at least two out of the first three were, they weren't routine. They were just done when the committee had questions. And two of the first three times this happened was with our first two Jewish nominees, who were essentially pressed for their loyalty to the country, and with really kind of episodes dripping with anti-Semitism. Confirmation hearings become normal and routine in the middle part of the century, I think in the 50s, with nominees showing up. Used to be just a few hours. They stretched out, and they sort of expanded and contracted. I think the longest hearings were for the Bork nomination in the 80s. But we've mostly now settled around a 4-day process, which we saw this week. First day, opening statements, 2 days of questioning, fourth day for outside witnesses. The whole length of this has also varied. If you go before Bork, they were a month, 2 months. After Bork, they got a lot longer. Ginsburg, as it says, was the shortest, most similar to the timeline we're following for Barrett. But most noms in the last 40 years have been about a 3-month process. One of the ways in which this nomination was able to be so much shorter is they cut down on the time between nomination and the hearings a great deal. Normally, there's a couple months of the nominee preparing and meeting privately with senators. These private meetings, called courtesy meetings, can be more or less courteous. And they're all really, really different. I worked for 3 senators, each of whom handled it very differently. My first boss was Chairman Specter, the chairman of the Judiciary Committee. I mean, he came in armed with probing legal questions. I worked for Senator Thune from South Dakota, who's a really affable man and not a lawyer. And he just mostly wanted to know where you're from, how you feel about this, how are your kids doing? And it was just a very social event. And there's sort of everything in between. It depends, of course, if the nominee is from the same party as the senator, may take on a different tone. These things used to be essentially reserved for Senate leadership, maybe home state senators and Judiciary Committee members. They have become more routine, and in recent years, close to the entire Senate has had these private meetings. And there's a little bit of strategy to this too. Sometimes the minority party likes to schedule these meetings because it eats up time that the nominee would rather spend preparing. There's also this public relations fight you get to have because by custom, nominees don't speak to the press. Senators do. So senators can have a private meeting with a nominee and then go out and talk to reporters about what they heard in that meeting. And they get the gloss on it and they get to shape the news coverage of it without much opportunity for the nominee to respond. So there's some risk in these meetings, despite sounding cheery at courtesy meetings. The last nomination to fail was Harriet Miers, George W. Bush's nominee, who I worked on that nomination as well. I mostly talk about Alito and Roberts because those have happy endings. But Harriet Miers' nomination essentially failed because her courtesy meetings went so poorly. And Republican after Republican was somewhere between frustrated and disappointed to outright opposed coming out of several of those meetings. So these things can have consequence, and they're mostly behind the scenes. I'll say that's true of a lot of the confirmation process. We see the hearings and the floor debates, but it really is an iceberg situation. A lot of the work happens behind closed doors. A lot of the consequential work before and after nomination happens behind closed doors. So yeah, I already mentioned.
I think you already talked about
Sorry,
this.
I jumped the gun on that, but
Right. So,
on the length and structure of the hearings.
So there were 2 really good questions about confirmation hearings. I wanted to make sure that we wove in somewhere. One of them was that there, specifically with this nominee, but I think for others as well, there's been a lot of attention to adherence to stare decisis, and how important is that question when it's asked to this nominee, but any nominee. And then also, how often do confirmation hearings impact senators' votes? So, are they going in knowing how they're going to vote already? Sure they're going to vote party line, or do confirmation hearings change senators' minds?
Yeah, well, so I'll take it back. I'll take that one first. It's as the country's become more polarized, parties more polarized, and the parties more lined up with ideology about who should sit on the court than perhaps they were a generation or 2 ago. The Bork hearings, there were lots of Republican votes in play. That's less true now, and part of it's because we've become polarized. Part of it is also that the stakes in Supreme Court nominations are so high that neither party wants to take a chance. So you don't see moderates on the Judiciary Committee anymore. The leadership of each party picks folks that they know they could count on, particularly for this reason, for the Supreme Court confirmation hearings. The votes that are in play do not serve on the committee. So the votes of the Judiciary Committee members are no longer in play. The handful of votes in the Senate that are in play will be watching the hearings, and the hearings could have an impact on their votes. So no to Judiciary Committees, but I think yes to the 5 or fewer senators who are realistically in play in an ordinary nomination. With respect to the CISIS, I'm trying to think of a a response that's fair without betraying my several biases. Stare decisis is the idea that the Supreme Court should respect its own precedents. And lots of people speak passionately about how important that is. They tend to believe that most strongly when they agree with those precedents. I mean, every Supreme Court justice almost every year votes to reverse some precedent of the court. I mean, everyone is open to doing that. The question is only on what basis. And so you have this conversation about how strongly to respect prior cases, particularly if you think the case is wrongly decided. With conservative judges who are supposed to be originalists, maybe it's particularly stark because they're saying that the court's highest duty is to apply the Constitution as it's written. And well, what if it conflicts with a prior precedent of the court? What do you do? So Barrett has written a lot about that and has some interesting things to say about the general approach. And I think conservative judges differ on this. Famously, Scalia and Thomas were very different conservatives, Scalia respecting precedent more than Thomas. But you know, it's an important question of judicial philosophy. In the Judiciary Committee hearings, it's often just a stalking horse for Roe versus Wade. And that's what's driving many of these questions. They want to know if a justice or nominee will uphold Roe versus Wade, even if they think it might have been wrongly decided as an original matter. Hope that was helpful.
I mean, the one thing I would add to that, it's important to remember that there was a time when the Republican Party was a mix of liberals or progressives and conservatives, and the Democratic Party was a mix of northern liberals and, you know, southern Democrats who were weren't even close to being moderate. So the parties, they were just very different animals back then.
Yeah.
Remember, you know, more Republicans voted to pass the bill than did Democrats.
Yeah, it's amazing. Jack, I don't know if that broke up for others, but I think Jack was saying that more Republicans voted for the Civil Rights Act than Democrats, which, yeah, it's a remarkable kind of historical fact. The parties have changed a lot.
Yeah.
Okay, so maybe we'll try to move quickly through the next couple slides so we can get to some Q&A, but I would like to hear your insights on how nominees prepare. And someone also asked a question about how the senators on the Judiciary Committee prepare. Like, do they read all of the justices' former, you know, decisions and things?
Yeah, I'll just quickly answer for the committee, and Jack, I guess, can answer for how the White House prepares nominees. The Judiciary Committee gets a supplemental appropriation of funds when there's a Supreme Court nomination, and they hire more staff, more lawyers to read everything the nominee has ever written and prepare legal memos. So yes, the senators, they're not all lawyers, and some are more or less interested in legal work. So I wouldn't say they all read everything, but they're all briefed on everything by their legal staff. We also, everyone I worked on, in addition to preparing them on the background of the nominee, we would update them on the law. So I prepared a binder of many memos on kind of the state of disability law in America today, the state of criminal law, any kind of issue that they might be interested in knowing about, and they might want to explore where the nominee engaged with those subjects. So there's a lot of legal work that goes into it by staff, but the senators, you know, are interested, and again, depending on the senator, some get more in the weeds than others.
Okay, then once it comes out of committee.
I don't think we can.
Okay, sorry, Jack.
No, I was just going to say, I don't think we can say that all senators commit themselves to study and reading to an equal extent.
Sure.
Okay.
Yeah, and so the nominee, I just say, you know, the nominee prepares as well and reviews their own history, and typically does mock mock hearing sessions over at the White House or with lawyers from the Justice Department.
Yeah,
Senators.
you know, I had the privilege of sitting in with Justice Ginsburg, and you know, we had a little room in the what was then the old Executive Office Building. It's now called the Eisenhower Executive Office Building, across the street from the West Wing. You know, where a dozen lawyers sort of helped her get ready. In fact, this was at the first meeting. It was just sort of going through what we expected from, and what should she thinking about in terms of answering difficult questions.
Right. Okay, then what happens in the full Senate?
Yeah, so the precedent of the Judiciary Committee is to not ever defeat Supreme Court nominees within the committee. They have the choice of, they could always break their own precedent, but historically, they either vote the nominee out with the committee's blessing, or they can consider voting it out with a no recommendation, or voting it out with a negative recommendation. I think the only time that has happened is Bork, who was reported to the Senate with a negative recommendation from the Judiciary Committee. The Senate receives the nomination and debates about it for a few days. Usually every senator wants to speak for at least 10 minutes on this, so the floor debate can take 3 days or so, and then the Senate votes. And now this is super complicated, we're running long, so I don't want to get into the weeds on this. There's really interesting procedural issues here, but basically there used to be the possibility of a minority of the Senate blocking the confirmation of a judge or justice. It was historically rarely used, became commonly used against Bush and Obama judges, has never been effectively used against the Supreme Court justice. And that practice through a procedural gambit is no longer possible. So now it's quite clear that Supreme Court justices only need a majority vote for confirmation.
Great. Yeah, and there you can see the breakdown from the very last vote, the Justice Kavanaugh vote. Great. Okay, and Jack, would you like to add anything to that before we get to Q&A briefly, or should we just jump into Q&A?
I told you the other day my favorite anecdote. If you give me 90 seconds, I'll tell it.
Absolutely.
And the story originated with, or came to me from a member of the Senate Judiciary Committee. I won't mention the Supreme Court justice, but the Supreme Court justice went to see Senator James Eastland from Mississippi. So obviously this was quite some time ago. He sat there with the president's nominee, and he was puffing on this big cigar, which back in those days, a lot of these guys, especially from the and the poor nominee was sitting there probably getting sick from the cigar smoke and wondering when the senator was going to speak. And then finally, Senator Eastland said, "They're going to approve you, you know that?" And Eastland said, the nominee said, "Well, that's great to hear. I'm pleased." And Eastland said, "You know why?" The nominee said, "No, sir, I don't." He said, "Because they think you're going to die." And given the source, who is a revered, very long-serving member of the Senate from the great state of Massachusetts, I believe it.
Okay, so that's a great anecdote. It leads us into some questions. So I have to admit that I'm going to give preference to questions that are dealing with the nomination and confirmation process over just questions about the judicial branch, even though there are some great questions. But since that's the focus of our webinar and that's what people tuned in to hear, I think we'll try to focus on that. So there were a lot of questions about, in general, the process, and particular interest, I think, in how, if there is any way this confirmation is not going to go through, if there's anything procedurally. So the two questions I'm thinking of are the questions of the questions that were submitted. Is there anything else besides preventing a quorum the Dems can do to prevent the vote, the ultimate confirmation vote in the full Senate? And what Senate procedural rules, if any, could the Democrats use to try to block confirmation before the election? So those two questions sort of taken together.
Yeah, I'll take it. Basically, the answer is basically none. The only really on paper rule that they could attempt is the quorum issue. I believe you need at least one Democrat present on the vote, or one member of the minority party present on a vote in the Judiciary Committee to report the nomination out to the full Senate. But committee rules can be changed if needed to be changed. And there's other tools the full Senate has to just order the discharge of a nomination from committee. The sergeant at arms could physically pull Democrats into the room. So there's lots of ways that, with varying degrees of elegance, that Republicans could get over that. So it would really be performative. If there's without the filibuster anymore, there's no real way for the minority party to stop an election, to stop a vote, or even to drag it out more than a few hours, maybe a day. And there's enough play in the joints for that to not push it till after the election.
Jack, did you want to add anything to that, or?
No, I think making the Senate go through that would reflect badly on the minority party.
There's a question in the Q&A queue about, it says, interesting that President Obama nominated a Supreme Court justice that does not have much of a judicial record at all. And they were talking about Kagan.
Yeah.
Kagan. Is it true that she never held a judgeship? And I'm asking that question because it sort of combines a lot of the questions that were asked about sort of, what's the pedigree that they're looking for? Yeah. We hear a lot about the fact that, the DC circuit, sort of like a farm league for the Supreme Court. But is that important to have that judicial experience? And of course, because much is being made on both sides about Judge Barrett's qualifications. Some people are saying, she only has 3 years on the bench. Some people are saying, but she has 3 years on the bench. So I guess that idea, and Greg, I think you mentioned briefly earlier that, or maybe it was Jack, that we've had justices before that have not been judges.
Yeah, and by the way,
sort of in this current era, how important is it, that judicial experience?
Let me come to that in a second. I mean, Elena, by the way, was nominated to be on the DC circuit, but she didn't get a vote. And so she never served on the DC circuit, but she was an honorary member by being nominated. I'm joking. I don't think that, I don't think it's essential to have had experience on the bench. I mean, it's not an essential. Is it helpful? Of course it's helpful. It's good experience. But it's just not something that is a requirement. Again, there are no real requirements. And I think that, Elena doesn't suffer from not having been on the bench before, I don't think. And by the way, she worked for me in the counsel's office. So I heard a lot about when she was working in the counsel's office about how much she'd like to be on the court.
Yeah, I mean, sorry.
Okay.
Yeah, I basically agree with Jack. I mean, I think there's a bias towards it because it's easier to sell. People understand experience. Senators, like to see a record. On the Republican side, for Republican nominees, Republicans do have this frustration that many Republican Supreme Court nominees have turned out to be moderate to liberal on the bench. So certainly Republican interest groups want to see track records more because they feel like they got burnt on earlier nominees who had relatively light track records. Also, there is just sort of a bias towards experience. I think I was working in the Senate for the Kagan nomination, and one Republican senator who was in play, who had voted for Sotomayor, voted against her. And his entire reason, at least privately, was he just didn't like the fact that she had never been a judge. And he said something along the lines of, you know, you don't I don't know, you don't go, you don't, if you want to be a coach, you don't start off coaching the NFL. You get experience somewhere else. You had like some anecdote, like, you know, some metaphor like that, and felt strongly about it. And so if you're just, you know, if you want to, there's a bias towards credentials, a bias towards perceived excellence, which is probably also the reason that every member of the court went to Harvard or Yale Law School. Barrett will change that, but.
Well, sort of in that same vein, since you're talking about law schools that aren't Harvard and Yale, there's a question here about, I have to ask because it sounds like it's coming from students through the teacher, about students asking if Barack or Michelle Obama could ever be considered for the Supreme Court, because they both are lawyers, obviously. Do you think they would ever be considered? And then I want to ask one more question before we go. So maybe briefly, but you know, if there were a Democratic president in the future, would they be considered? Could they be considered?
Yeah, I mean, sure, they could be considered, but I don't know exactly how old they are, but I'm going to guess that they would, you know, be deemed to be too old. Plus, I doubt they'd want to do it.
Right. So we could have another President Taft, right? President Taft was on the Supreme Court after his presidency. So.
Correct.
Right.
Okay, so I did want to break my own rules about not asking questions not about the nomination and confirmation because we had 4 questions submitted about court packing, and I won't read them all because I'll take all the time we have left because we only have about 2 minutes before I need to wrap up. But generally the gist was, you know, do you think there is a chance that this court packing thing will happen? I'm paraphrasing, obviously, but your views on court packing. The idea of adding more, and I'll define that because there's been a lot of controversy about what that means, right? The idea of adding more justices to the bench in order to change the balance.
Let me start, if I may. First of all, Franklin Roosevelt, President Roosevelt, went down that road. It didn't have a very good result. It was wildly booed and didn't serve to time. These are different times, and I wouldn't for a moment say that circumstances might not develop where it would be deemed by some in the Democratic Party to be important to do that. I would note that Vice President Biden, I think 2 days ago or so, said something to the effect that he's not nuts about that. I'm not sure if that's the right phrase he used, but it was something like, not what?
Not a fan, or not a big fan.
Not a big fan of that. So he doesn't want to rule it out, but he's not signaling that he thinks it's important right now to rule it in, and he wants to talk about other things. So I wouldn't say it could never happen, but I think I wouldn't bet my next paycheck on it.
Yeah, I would just add, if we still have a few minutes, yeah, I'm in the same place as Jack. Whether it happens will depend on several things over the next few months. One is the margin. If Democrats win the majority of the Senate, I expect they would need more than a bare majority to be able to get it done. I think they are likely, or they will have trouble holding every Senate Democrat together on that. Because it means getting rid of the filibuster, and frankly, the filibuster helps protect senators in difficult states from taking hard votes, and they're not going to want to easily get rid of it. So I think it's probably off the table unless they get at least 52 Democrats in the Senate, maybe 53. And then it depends on the course of the next 6 months after the election on, is there a conservative Supreme Court decision that is radicalizing to Democrats and to the populace? Or is there some high priority piece of legislation that fails against a filibuster that's perceived as unreasonable and obstructionist? So I think they need to have the numbers, and then I think they need to have a triggering event. And I don't think either of those things are foreordained. So I'm going to bet against it happening, but it's certainly within the realm of possibility.
Great. Okay, I'm gonna just mention a few resources we have for teachers if you are bringing this topic into your classroom. And the first one, Gregg helped us out by reviewing. So we have a short explainer that is just a short document that explains a lot of the things that we talked about today, sort of how the nomination in 2016, of course, I'm talking about Merrick Garland being nominated, and then Justice Gorsuch getting the seat in the end, and then our current Supreme Court vacancy. And when you go to the document, you're going to see a link, because this is going to be updated as things progress. So at the moment, it only takes you through nomination, but of course, after there is a confirmation vote and things, it will be updated. So keep checking back. There's also a whole lesson if you want to do a lesson with your students on what makes an ideal Supreme Court nominee. And you can use a lot of the things that you learned today from Jack and Gregg about, why certain people are tapped for this, and why and what makes them, attractive to presidents who are making nominations. If you're trying to do all these things remotely, we do have a web page about using our materials at home that might be helpful. To keep up with us, to find out about more webinars like this, you can follow us on social media. It might be how some of you found out about this. And you can sign up for our email updates. I will put this in the document as well. And lastly, because I have to get in a commercial for my program, please apply if you haven't already been to the 2021 Supreme Court Summer Institute. Hopefully we will be in person. I'm knocking on wood as I say that, in June. It's 6 days of intensive study about the Supreme Court, and you'll get to meet awesome experts like the ones that we have seen today. Applications have just been opened, and they will be open through March 15th.
It's really an amazing one of its kind program. I mean, I'm just so impressed by what you all do and who the teachers get to meet and learn from. I can't believe you let me speak at this thing.
Yeah, well, I hope we get to do it in person this year. And if we don't do it in person, likely there will be some kind of a virtual substitute for it. So of course, we want to thank Jack Quinn and Gregg Nunziata for helping us today. Thank you so much for lending your expertise, and thank all of the teachers who came after a long day of maybe teaching in person or virtually teaching or hybrid teaching. So we appreciate the fact that after a long day that you came to spend time with us. If I can help you with anything, there is my email. And thank you again for attending, and have a good evening.
Thanks, everyone.
Thank you.
Thank you.